Right.
Well, welcome to Introduction to Law. My name is John. Getting a bit of background noise through the computers, but we're right now. I completed my studies at University of Queensland, where I did my Bachelor of Laws degree. I did my articles of clerkship at a firm called Cannon and Peterson, as it was then. It's now Northern Rose Fulbright. I was admitted as a lawyer in 1984. My practice is primarily in criminal law. That has been the case for the last 15 years, but I have had experience in most areas of practice. The practice like mine, which is a relatively small practice, where people do time to time come and go, you find yourself taking over their area of practice, and I've had a number of opportunities to morph, if that's the right term, from one area of practice to another. And it's interesting because, let's say, for a period of 5 years, I may have been doing family law work, so that when someone comes in and sorry, I'm just finding it very noisy there, Anastasia. Is that the children in the background I can hear?
There's a 3-year-old running around. I'll be back in a minute.
All right, thanks very much. I'll continue.
John, I was interested to hear you talk about Cannon and Peterson. They're a very long-established firm. I used to work for a property developer in Brisbane, and we dealt with them. I was interested to hear that point.
Yes, my masters there were Greg Vickery and Don Boyd and David Nichols.
Right.
Coming back to the screen, and we had Victory there briefly, but she's gone again. Before we started broadcast, Anastasia was saying that she has 10 children. Sorry,
yeah, that's right.
Sorry.
No, that's all right. Thanks very much, Anastasia. I appreciate it. In addition to being a lawyer in private practice, I am also a member of QCAT, which is the Queensland Civil and Administrative Tribunal. That gives me an opportunity to sit on the other side of the bar table and hear cases. As the name implies, the cases are civil and administrative in nature, and that includes work such as building disputes, guardianship matters, blue card matters, other administrative matters. I am also a tutor, mentor at this university, and part-time lecturer and course coordinator. I established the Hervey Bay Community Legal Service with Magistrate Steve Guthridge, as he is now, and Steve was my partner in this law firm for many years. I am nationally accredited as a mediator, and I was part of the steering committee for establishing the Fraser Coast Anglican College. I was chair of the Anglican College in Hervey Bay for about 5 years in the 90s, and I've only this year gone back and become a council member once again. So that's some background to me, and thank you for that. I just want to make a few comments about the study of law. Firstly, there is no such one thing necessarily as the law. The law is fluid and cyclical. Now, you're probably aware, of course, that Parliament creates the laws in the first instance. The parties that are involved in a dispute, let's say, whether that's the police and a defendant or matters involving civil litigants, will then perhaps engage lawyers who go to courts. As a result of that, there's a disagreement, and the dispute is determined by the courts, who have the role of interpreting those laws. But that's not necessarily the end of it as well, because the judges will disagree, there will be appeals, they may be successful, there may be split decisions, but ultimately the law then continues on its path of, in its fluid nature, having been established by Parliament. It's then interpreted by the courts, and once we have that situation, we go around again because the community and Parliament react, as they often do, to how the courts have made a decision. And I say it's cyclical because then the Parliament creates new laws and away we go again. Even then, it's not the end of the matter because we have a Parliament that is a new Parliament that's elected, the old laws are repealed, and we start again. So it's very difficult to say with any certainty what the law is at any one time. It's constantly changing by its very nature. So the study of law is constantly changing. It's subject to interpretation by people, and in essence we have the parliamentary law, which is through statutes, and the common law, which is the body of law made through decisions of the courts. So the study of law in many ways is really a study of legal process. An interesting part about what I've said is this, that there is not necessarily a single right or wrong answer when considering legal issues. In that sense, it's very different to studying perhaps mathematics or physics, where there may be a greater perceived amount of certainty. So there's not necessarily a right or wrong answer. We can carry from that, therefore, a lawyer who says, I'm not sure what the answer is to that particular problem, might be wanting in legal knowledge, or conversely, may have a great deal of legal knowledge. I think you should be careful to be wary of simplistic answers. And without wanting to be critical, paralegals sometimes can be guilty of thinking in black and white terms. Say, for example, in conveyancing matters, that this is the way we've done things, therefore it's right, without necessarily thinking about the whole background of the statutory law and the common law, which can sometimes have an effect on the issues that are under consideration. Now, there is a further distinction between black letter law, which is the law if you like, and equity, and you've probably read about that distinction already. So black letter law, or statutory law, purports to be quite simple and straightforward. These are the rules and that's it. Equity, which is based on fairness, intervenes in circumstances where it needs to do so. And so when you're studying the law, you'll be aware of this apparent conflict between what we might call legal issues and equitable issues. So law and equity is sometimes regarded as something of distinction, but collectively it is all the law, if I can use that term. I think from a criminal law perspective, the distinction between the black letter and issues of fairness can sometimes be seen when discussing the issue of mandatory sentencing. So, for example, the Parliament, perhaps tired of soft magistrates, as they might be perceived to be, introduces a law to say that if you're caught with a drink driving reading, which is a major reading, more than 0.15, within a period of 5 years, 3 times during that period, then you must go to jail. The problem with that type of regime is that there may be special circumstances which make the application of that law inappropriate or unfair. For example, someone may be caught simply sleeping at the wheel, having had a few drinks. The intention was to listen to the radio. They may have had no intention whatsoever of driving, but under our law with the deeming provisions, they're guilty of drink driving or a drink driving related offence, and can be subject to certain penalties that may not have been intended by Parliament when these laws were first made. So when we talk about law not being certain and something which is subject to argument, let me give you an example. So if I was to suggest that red is the most important colour and argue in favour of that, and you would argue against that, perhaps arguing that green is the most important colour. See how that pans out. I say that red is the most important colour, not because of the colour itself, but because of what it represents. Red is the colour of love and passion. These things are what drive us as human beings, and therefore, by its very nature, what it represents. Red must be the most important colour. You say, no, green is the most important colour. It represents life, it represents living. Without green, we can't exist. Therefore, it doesn't matter about our passions, etc. Now, what I've described is really, in very simple terms, something like a debate. But let's think of it in the context of a legal situation. In a legal situation, we have to consider what are the statutory provisions, and also have courts considered these sorts of questions in the past. So that therefore removes what might be perceived as an argument in a debate situation into a more legal context. So when we're arguing about legal matters, we've got to think about what the Parliament has made by way of statutory laws and how the courts have interpreted those things in the past. And then we need to consider the procedures involved as well. So, for example, does anyone in that scenario that I've outlined, in arguing that simple matter before a tribunal or court, who carries the burden of proof? Who has to prove that, and if so, to what standard? If it was a criminal law matter, prosecution need to establish their argument in prosecuting beyond reasonable doubt. If it's a civil matter, the plaintiff, the claimant, if you like, generally has a burden to prove it on the balance of probabilities, what's more likely than not. So you see, a simple debate is therefore complicated by having to apply the statute and consider the common law, and as well as that, think about the procedure and who carries the burden of proof and to what standard. Another distinction that I'd like to make between debates and arguing in court is that in courts we're really concentrating on the process of advocacy, which in my view is more about persuasion than ear bashing. I remember as a youngster doing some debates and some of the teachers encouraging us to be very dogmatic and boisterous in our approach, almost to the degree of taking rolled up pieces of paper and hanging them on the table as if to emphasise the point, to persuade. Well, in law it's not a political speech, it's more about persuasion. So if you do have an opportunity to go into a courtroom, have a look at some advocates who are very good, you might be surprised as to how quietly spoken they are and how polite they are, sometimes seemingly to a fault. That's not always the case. You'll always see some, some boisterous activity and some dogma perhaps in a courtroom. But generally speaking, the good advocates are very persuasive and calm and polite. And I guess you've got to think of it in terms of the person who's making the decision. You're not trying to bash them into submission, but you're rather trying to present something to them that they can adopt. So if you're able to put yourself in a position where you can create a logical scenario, some logical steps for people to follow, then you're in a better position for them to make the decision the way you want. You've set it out for them. All right. Now I'm going to suggest something quite different off topic, and that is I'd very much like for you to think about some movies that you'd like to recommend to your fellow students. Movies that might help inspire you or educate you during the course of your studies. I'm going to put two before you. One is called In the Name of the Father, and I would describe that as a movie about a lawyer making a difference. And the second is a movie called Promised Land, which is all about persuasiveness and ethics. So if you're feeling in the mood, have a look at those movies, In the Name of the Father or Promised Land, and please let us know of any other movies that you'd like to recommend that we all have a look at, because you believe it will assist us. Now, the prescribed text.
John, can I just make a point?
Yes, Raymond.
I think a third movie would be To Kill a Mockingbird.
Ah, yes.
Which is a very old movie, but it became a very famous movie in as much as the, you might say, society and those out of society, black and white at the time.
Absolutely. Gregory, wonderful movie based on the novel by, was it Harper Lee? But yeah, wonderful movie. And certainly one that I would also highly recommend and endorse. All right, thank you for that, Raymond. And we'll look forward to receiving your information from all of you as to movies that you recommend in the future. And books. Now, speaking of books, this is our text. The New Lawyer, James and Field. I'll be referring to that a few times. I trust that you're all reading that. I think it's brilliantly written, very logical, and I think very useful. It does make comment in the book, or the authors make comment in the book, that there are 6 threshold learning outcomes, and that's at pages 25 to 27. And those learning outcomes: knowledge, ethics and professional responsibility, thinking skills, research skills, communication and collaboration, and self-management. So what really stands out to me about that book, or that list of 6, and this may surprise you, is that knowledge is simply one of the 6. Now bear that in mind. That's a big difference between law and perhaps some other disciplines. Knowing the law is just a small part of it. It's all got to be done in the context of those other skills, which are, in my view, just as important. The way in which the book is laid out, you'll see part 1, which relates to chapters 1 to 5, deals with the issue of knowing the law. Part 2, which is chapters 6 to 10, is all about doing the law, and part 3, chapters 11 to 14, is all about being a lawyer. So keep that dichotomy in mind as you work your way through the text. Now, a few words about law as a profession. Originally, law was, as a profession, almost by definition, a profession is one where the participants are self-regulated. When I started law in 1984, that was largely the case, but that has progressively been eroded over time. So that now, as a profession, I'm not saying this is necessarily a bad thing, but like many other professions, we are subject to outside rules and influences. Certainly the Australian consumer law, which is important legislation, now applies to lawyers as it does to other professionals. And we have our lawyers are subject to the scrutiny of an independent body called the Legal Services Commission, and the Legal Services Commission has the power to prosecute, and in relation to unethical or inappropriate behaviour, that body can deal with those issues. And if you're not happy with the issue, then you can make an application to QCAT, which is part of my jurisdiction as a tribunal member. So that's the issue of self-regulation. Lawyers now practice in a vast range of different environments. I'm going to endorse that you might consider thinking about one of those different categories or the different environment that lawyers can practice in now, with a view to determining at this stage, in practice, where would you like to find yourself working? that is for those people that are doing this course with a view to becoming a lawyer. I think that there are considerable advantages in specialising in some field of practice or area of practice. The field of study is certainly less broad, and practitioners are able to charge generally a premium for their specialist skills. So you have the advantage of having to know less, but being able to charge more if you consider specialising. It's very hard if you purport to be an expert on everything. It's really hard work to do that. You'll be amazed at how much law there is to grasp, but then having grasped the law, coming back to my first point about law being cyclical, it's a never-ending process of trying to keep on top of it. So try to think about some specialist areas, and apart from thinking of and recommending some movies, I'd really like you, through Moodle, to start putting forward some suggestions on where you would like to practice in law, whether you want to be in criminal law, whether you want to be in personal injuries law, administrative law, there's a whole range, migration, conveyancing, property. So just let us know what your particular interest is, and maybe we can collectively talk about that as well. Some of you may have come to the law from an outside industry, for example, the Queensland Police Service or the Australian Tax Office, or maybe even a different profession altogether. It might be engineering, for example. And already, as a result of that, you are potentially at an advantage over others in that you have some specialist knowledge which isn't readily easily obtained. For example, if I was a client and I needed to litigate against the Australian Tax Office in a taxation matter, or if I'm a solicitor wanting to brief counsel in that field, I would be very interested in talking to a barrister who had previously worked for the Australian Tax Office, perhaps as an accountant, because I would expect that they would know the strengths and weaknesses of the opponent, having worked for the opponent. Just something for you to consider as well. Now, in my practice, I might describe it as a pretty gritty practice. I'm representing clients primarily in criminal law. I'm hearing cases in a tribunal setting, and those cases, for example, this week I'm hearing cases in relation to an application to have a tree destroyed, a neighbourhood dispute. I'm hearing a case about a decision by a council to declare a dog as a dangerous dog. I'm hearing a building dispute in relation to a building contract that's gone wrong. And I hear other cases such as a review of a decision to deny someone a blue card, or other administrative decisions such as decisions made by the Department of Child Safety. So for me, it's a really gritty practice. You know, you'll see the sleeves are rolled up. It's more than figurative. That's sort of indicative of the way in which we go about our practice. I'm certainly not at the top end of town. In the material, you'll see there's an exercise about having a look through the websites at some of the top-tier firms. Certainly the firm that I did my articles at is very much a top-tier firm, so I have had that experience. But have a look at it and get a feel for it, and start to think about not only the area of practice that you want to work in, but the type of activity that you want to pursue. Try and get a feel. Do you want to work for the government? Do you want to work for a private small practice, etc. Now, I will just say that I'm about to, I'll probably go just another few minutes before we shut down this telecast, and we can then continue at some other stage during the week or next week.
Right.
Okay. Now, just coming back to the new lawyer, you'll see in Chapter 1 comments made about the realities of legal practice, pages 7 to 10. Lawyers help people. Lawyers give clear advice about complicated problems. lawyers are negotiators and advocates, and lawyers read a lot. And that's all very true. The attributes, as we go on to page 10, are set out. Clarity of thought, good communication skills. I would say even better listening skills is important, really important. Being well organised is critical, both in your study and practice. I think you need to be technologically capable. You need to be committed. I say jokingly that 6 o'clock in the evening is not knock-off time or overtime, it's afternoon tea time. It's just the reality if you want to practice in law privately. You need to be personable. You need to get on with people, mostly. You certainly need to be flexible and understanding and tolerant of people. I do in my gritty practice, but I'm sure that it's the same for people in the top end of top-tier firms as well, and the big end of town. And you do need to have analytical and problem-solving skills. So they're the attributes on page 10. So have a look at that as well. Just a few comments about solicitor work sectors. That's on page 13. Solicitor or barrister. In Queensland and New South Wales, we have separate professions, whereas in other states we have a merged profession. And I'll leave you to read about that, and I'll leave you to read about where you could also work in terms of private, government, academic, corporate or community sectors. All right, my time for the moment is just about up. Before I leave, Raymond, is there anything that you want to ask or any comments that you wish?
No, John, I was following you without any problem at all, and I had a preliminary look at the new lawyer, so for the first chapters, for the first lecture. So I had no particular problems in following exactly where you were leading.
Excellent. All right. Well, thank you very much, Raymond. I appreciate
Good,
that.
John.
Okay. Look, I'm going to now upload this onto Moodle and the internet and invite others to have a look. All right.
Good, John.
And what we need to do is each week there will be a new section where you click to join the Zoom session. So it will change every week. All right. Well, I'll end the meeting at this stage, and thank you very much.
Good, John. Thank you.